Oops. All right. It can be very difficult for a disabled person to get situated. No viewers anywhere right now. That's before the regular anyway. All right, here we go. All right, I'm here at the courthouse. I have an appointment at 3 o'clock with the Phelps County Prosecutor. They like to ignore a lot of my emails. So I'm going to show up here and see if I can get some answers to a couple things. I'd say unlikely, but we're going to try. Yes, I had a 3 o'clock to meet with Brendan Fox.
Right this way.
You Mr. Fox?
I am. Have a seat. Make yourself comfortable.
Well, I figured since you don't want to respond to any emails, I'll come down here.
Okay. How can I help you today?
Well, there's multiple things. I guess the first one is in one of your emails, you said that I didn't have a court date because I wasn't charged. Why was I fingerprinted, arrested, booked, all that if I wasn't charged? You may not have prosecuted the crimes, but I was charged.
I think maybe we're using different definitions for charged.
Well, I'm using the legal definition.
So-
You're charged and then you're prosecuted on those charges.
So the term being charged means having a case filed against you. So that means the filing of an information, indictment, or complaint. And none of those were ever filed.
Well, why was I fingerprinted then? I mean, there's no file. I'm on record. There's record of all of this.
Correct. You get fingerprinted anytime you're arrested.
Okay.
And you get fingerprinted because they tag fingerprints to, it's an OCN, which stands
Right.
for offense cycle number.
I understand.
And that is what goes on to a record, like maintained by the Highway Patrol mules.
Right.
And that is to identify the person associated with that record. It could be that the person is arrested and charged, and then the case is adjudicated. It could be that they're arrested, charged, case gets dismissed.
All right. I understand what you're saying. I don't want to waste a bunch of time on that aspect of it, I guess. So one of the things that I was charged and arrested with was possession of my medication, which is a felony. And they charged me with that. And I don't know what other word to use, because in their system, in the report I have, it showed charged.
Okay.
As far, charged under RSMO number.
Sure. Okay.
So that's why I'm using the definitions that were on the paper I had.
Okay.
So I don't know what else to call it. Because I was booked, I was handcuffed, booked, and fingerprinted. Documented all this, and they brought the case to you to see if you were going to prosecute. You chose not to.
Correct.
Very smart on your part. I mean, if you're going to go after me for my medication. But that seemed to be the main sticking point of Captain Hope for trying to keep me in there was my medication.
Okay.
So does Phelps County have a habit of, I guess, charging people for their medication, charging them with a felony, being brought into booking against their will, first of all? I mean, I have the statute right here. Any controlled substance, and this is 211.111.
Yeah, I'm familiar.
Yeah. Except upon the written or electronic prescription of a licensed physician. Not only do I have that, I provided them with the license from the state of Missouri that says I am allowed to have that on my possession, on my person.
Okay.
So I was still fingerprinted, charged, threatened with being held until the judge was going to see me for something that I can't legally be charged for in the first place. So is this a habit of Phelps County?
I can't speak for the sheriff's department.
Well, as a prosecutor, they bring these files to you. You would see them.
We don't get very many of those cases of somebody bringing
Prescriptions.
contraband potentially into a jail.
I provided my prescription. It's not contraband for me.
Well, you certainly couldn't take it with you into a jail cell.
Well, but then we get to that point. I was taken there against my will because of
Most people are
a
taken
camera.
to jail against their will.
Well, okay, I'm sorry.
Mr. Brooks.
I was charged for, exercising my rights.
You were held in contempt of court.
Right. Okay, let's get to that part of it, I guess. Contempt of court. have that right here, criminal contempt. But I also have, which you guys don't seem to be familiar with.
I'm familiar with court operating rules.
Okay. This says nothing about recording outside of courtrooms. Actually, it does. It talks about adjacent court, outside of, adjacent hallways and all that. But this also states in here that it cannot be strictly prohibited. That all camera use. It's actually the first line. No, this is the definitions. After the definitions, let's see, blanket prohibition by local rule of all media coverage is not permitted. That says right there that a blanket rule cannot be put in place. You said you're familiar with this.
I don't have it memorized, Mr. Brooks.
Okay.
I don't have all the legal
definitions. Phelps County arrested me on this. Correct. For being in compliance with a court rule. I was in compliance. I was never in non-compliance with this rule. And yet, is that sign still on that door up there?
I don't know. I haven't looked. Well, I'm not the circuit judge who makes.
But you're the prosecutor, so if they're going to under criminal contempt, under this rule that's up there now, under this order.
So this rule right here is a court rule.
Mm-hmm.
Okay. So that is established by the Missouri Supreme Court.
Mm-hmm.
This doesn't actually get anybody charged with a crime.
Okay.
Okay.
But I was arrested for it. So okay.
May I finish?
Yeah, go ahead.
I cannot file a charge against somebody citing Rule 3601. There is a statute that deals with criminal contempt. And so those are different things. Well, I have no authority over the courtrooms, the judges, the local court rules that they establish or promulgate.
Well, I understand that, but I guess the reason I'm bringing you into this is because if they're going to charge people, or whatever you call it, arrest somebody for that sign that's put on that door up there, then it's going to be up to you to prosecute. So
sometimes, if somebody's in a courtroom or in court,
right.
Hold on. Let me finish.
No.
If somebody is in a courtroom or in an area that is overseen by the circuit judges, then if they hold somebody or determine somebody's in criminal contempt, the sheriff's department, on their direction, will take somebody into custody.
Right. I know Beeger gave the order to have me arrested. They had him on the phone that day. I'm very aware of how it all worked. They actually asked him, and he specifically gave the order to have me arrested. I do know that.
I know.
Which I think you actually were there with him that day. I'm not positive.
I was in a jury trial with him. Yeah.
But yeah, so I guess I'm a little confused here because you're the prosecutor.
Yep.
And that sign up there I was arrested for, but let me ask you this.
Sure.
If I go up there after we are done with this meeting and record, am I going to be arrested again? Or, well, I guess you can't answer that.
Right, I don't know.
Will you prosecute me ever for recording in a public area that is not restricted?
I can't answer that question.
It'd be under these exact same circumstances. It'd be me holding the camera quietly.
Under the circumstances of a person not being otherwise disruptive, recording, that doesn't fall under any criminal statute.
Right, I know that.
But criminal statutes are not the only thing that can get somebody arrested. So violation of a court rule like this, you can be held in contempt.
But if that court rule violates a Missouri court or the Missouri court rules in general,
you might find this somewhat shocking, but there are laws and rules that contradict all the time.
Oh no, this is not shocking at all.
And so, could you be arrested for violating a court order like that?
Oh, I know I could.
Potentially,
it already happened.
Would you be prosecuted unless there was some violation of a state statute? No. So the way criminal contempt works is a court has the authority to take somebody into custody on contempt, and they can, it's been a while, I think it's up to 6 months, I'm not sure. Usually it's considerably shorter. But that is not involving my office.
Right. But I mean, so that's a little odd. So basically, the judge could circumvent the prosecutor on a crime that somebody be arrested for.
Well, that's where it gets weird, is because it's called contempt is one of those situations that's kind of weird, because they call it civil contempt and criminal contempt.
Right. Yeah, I looked both up.
But criminal contempt is kind of one of those things. They named it criminal contempt within the rule, but it's really not criminal.
They fall under civil?
No, they have to distinguish it, and so they give it a different term. Okay, so civil contempt, the distinction between the two is one can be, the term is purged, and the other can't. And so civil contempt is, so for example, if somebody were ordered to pay alimony.
Right.
And they weren't paying their alimony, the court could find them in civil contempt and hold them and set a condition that they could meet to remove the contempt.
Right.
So they could pay that money.
But see, that's where I guess I get
contempt.
confused, because
Criminal
this
contempt
involves
can't
only
be
the government,
purged.
has nothing to do with a private party. So I don't, that's why it couldn't possibly fall under civil
No, I'm
in
not
any
saying
way.
it's civil. That's civil.
Right.
The other one they call criminal, but really, I don't know that I would classify it as
And
criminal.
see, that's why when I
Rules.
looked this up, I didn't even print off the civil one, because I know the way the law works. The government can't be a party in a civil matter. I mean, well, I take that back. They can't be a complainant. For example, disturbing the peace. If it's only, there's nobody else around, it's only me and an officer, that officer can't be the complainant.
Correct.
Yeah.
But that's because there's like an assumption of risk, and you can't have your peace disturbed when you're doing that. But there are
Yeah.
civil lawsuits all the time that the government is party to. So,
Right. Not being an attorney, I mean, I understand things very well, but I didn't know exactly how to word that. Basically, I understand that what I was arrested for in December does not in any way fall under civil, because it involved
Correct. What
me
you
with the
were
court
arrested
system.
for was initially
Criminal.
well, again, it's contempt.
Right.
It's not civil contempt, so it's kind of one of those where if it's not civil contempt, it has to be criminal contempt.
Right.
Even though the use of the word criminal suggests that it gets you into like criminal court, but it really doesn't. It's more of like a judicial contempt.
Yeah.
And then upon being taken into custody on that, then when you were taken to the Phelps County Jail and going through the booking process, I assume, they located marijuana on your person.
Yes.
And I think this was in December?
December 16th.
And I think...
And actually, the recreational law had already passed. You couldn't buy it,
Right,
but it had already
recreational law
passed.
took effect on December 9th or something, because it was
Yep.
supposed to be 30 days after
Yep.
the election.
Which that's something else that Captain Rick Hope argued with me that day, telling me that it was still illegal. I said, no, it's not. It already passed. That just shows Phelps County Sheriff's Department does not know the laws of the state.
No, I think that shows one...
They don't know the laws.
officer-
He argued with me on it.
I think that shows one officer might not have been familiar. I don't
Well,
know
he
if
was
that
the captain that was threatening to hold me. Anyway.
I don't need to be here like arguing over semantics
Right.
with you, but
Exactly. But I do
so-
need to get to one of my main points. I am a disabled citizen.
okay.
I was injured that day. I was denied medical care.
Okay.
I would like to press charges. Criminal charges.
Against whom?
Jamie Arnold, he's the one who injured me. I would like to press charges against him.
Okay.
And then I'd have to look in the reports. The female officer, I don't remember her name off the top of my head. I don't have that printed. I can get that to you later, but I'd like to file charges against her as well, because I requested several times while I was down there for medical attention and booking.
Okay.
And booking.
Now, the female officer, was that a jailer?
Yes, she was a jailer.
Okay.
And while I was there, there were several times it was just me and her, and then there was another deputy, male officer, in and out, which actually threatened me because I was requesting medical attention.
Do you need to return this call now?
No, I'm fine.
Thank you.
So I was denied medical attention.
I'll call him back when I'm done.
All right, thank you.
And, you know, the Supreme Court of the United States has ruled that law enforcement has a constitutional duty to provide medical care to anybody in their custody.
Sure.
And it's against the law. It's a crime to withhold medical care from a disabled person.
That,
You don't think it's against the law to withhold medical care from a disabled person?
I'm not saying that, Mr. Brooks. What I'm saying is, I think what you're referencing would be a federal statute, if it's dealing with the American with Disabilities Act.
Well, the denial of medical care in general is against the law. The Supreme Court's ruled on it. I mean, I didn't print off that statute or the Supreme Court order,
Right.
but the Supreme Court, I specifically read it because being a disabled person, I was very curious. I went down a long rabbit hole and I looked it up, and the Supreme Court of the United States has ruled that in custody, law enforcement has a constitutional duty to provide medical care.
And if you have the case or the citation, I'd be happy to look at it. But
I can
don't-
email it to you if you'll even read it, because you have a habit of ignoring all my emails.
I'm not aware of a Missouri statute that would fall under what you're talking about.
Well, maybe that should be one of the things I sue for then. Try to get legislation passed to make that a requirement, because that'd be ridiculous if it isn't. Well, just to inform you, like I said in many of my emails, I'm a very peaceful person despite what my family's been through. I wish no harm on anybody. And with that said, I hope I don't get arrested for going to the circuit clerk's office, because I will have more business up there. I also need to record the positions of the cameras, which I've stated in emails, because evidence is also being withheld. I've requested camera footage and only part of it's been supplied, and all audio footage has been withheld.
To my knowledge, none of the cameras upstairs record audio.
But those ones, that's fine, but I know the booking ones do, right? They're required to, I believe. I mean, not required, but I believe they do have audio.
To my knowledge, I don't think any of the jail cameras have audio recording.
Well, isn't that convenient?
No, actually, it's not, because I have a lot of cases where it would be beneficial.
Except for this one where a disabled citizen was denied medical care after being injured. But there's also a camera angle being denied of when I was injured. That was conveniently left out. Camera angle looking at the elevator. But anyway, my point of this is I was just letting you know that I have no ill intentions against anybody. We're going to do this the right way, the legal way, through the court system. And my only goal while I'm in the courthouse at any time is to conduct legal business and gather information. Part of that will be needing to record. So if I'm arrested for that again, I just want to let you know that, I mean, if you want to prosecute me under it, I will represent myself against you in that one.
Well, I haven't had any referrals recently to alleging criminal charges against you, so I don't have anything to review and make a decision. I would just make a suggestion. When you are coming to the courthouse to record, stop in and just tell the bailiffs, hey, I'm here to record that sort of stuff.
Why do I need to get permission or let anybody know for exercising my rights? The First Amendment, and the Supreme Court has ruled on this as well about recording public officials in the course of their duties. I don't know if you're aware of that or not. I didn't bring that with me, but I could also provide you with that in an email. So I don't understand why I need to do that.
It's a suggestion to save yourself having every bailiff and every person come ask you what's going on, because as a general rule,
Or maybe the better option would be Phelps County get educated on citizen rights. And so when they, including all the people in the offices, that way when they see somebody with a camera, they realize they're well within their rights. There's no reason to call anybody. There's no reason to waste taxpayer time getting law enforcement involved, the prosecutor.
Mr. Brooks, I appreciate your position and your efforts to enforce your rights. My suggestion was more to make it easier for you.
Despite the 3 years of hell and torment, Phelps County, including yourself, brought it.
Mr. Brooks,
This right here, Derek Lewis.
Mr. Brooks,
I want to ask you about the case against my wife and myself while I'm here. That's case is closed.
sure, you can ask me. I don't know that I'll be able to answer it off the top of my head. It's been a minute.
Well, it's mainly involving the attachment. I asked you in an email. You had plenty of time to review and respond to me, but you never did. You seemed shocked to find out that there was even an attachment to this email. And then I asked you about it. You didn't have it. You had to contact Derek Lewis for it. Then he sent it to you and I got it. Why did you never look at this before? Why did you never look at this attachment of so-called best threats 3 while the investigation was going on and while the case was open?
I don't know.
You're the prosecutor. You prosecuted myself and my wife.
Yeah.
Yeah. And you didn't look at all the evidence? Oh, wait, we know you didn't, because who else did you interview? Who'd you talk to? Did you talk to his school? Did you talk to his counselors? Anybody that would have seen any signs?
Mr. Brooks, I
Of
think
physical
you have
abuse?
a fundamental misunderstanding of my job.
You prosecute based on words only. You don't look into anything.
I am not an investigator. I take what I am provided.
Well, you were provided with an attachment that you never looked at.
Yeah, I missed an attachment.
And you just say that nonchalantly, like it's no big deal. You miss a piece of evidence. You don't turn over a piece of evidence to the grand jury.
Mr. Brooks, I have since reviewed that, and that doesn't have any impact one way or the other on a case.
That is not up for you to decide. That is up for a jury to decide. Yes.
How does a case get to a jury?
Through the prosecutor, which you try to prosecute.
Wait, no. How does a case get from investigator?
We were waiting
to
jury trial until you dropped it, so I know exactly how we got there. So don't try to patronize me about this. I know exactly how we got to a jury trial.
How does a case get to a jury trial?
There's several steps. You want me to outline to you the entire process?
I'm wanting to make sure that we're talking about the same thing. So yes, please tell me.
For a criminal jury trial.
Yeah, how does a case get from charge to there?
Well, first of all, there needs to be an accusation. There's where you start. Number 1 is an accusation.
Correct. The police get called.
Okay.
They conduct an investigation. They provide information to the prosecutor.
Right.
The prosecutor then reviews it.
I know all this, yeah.
The prosecutor.
This is stupid to have to go. You said you didn't want to argue semantics with me, but you want to talk to me about the steps.
Not semantics.
I said you want to.
The prosecutor then.
This shows you don't listen to shit. Which is why you miss an entire key piece of evidence.
It's not a key piece of evidence.
Oh, it's not?
No.
Yeah. Okay. What would be? How about the juvenile case? Would that be evidence that you could use?
What juvenile case? The pending case through the juvenile office?
Pending case? What pending case?
At the time?
It wasn't pending. It was ongoing. It started before that started like a year before.
Correct. The case that was open at the same time.
Yes.
A juvenile case.
Mm-hmm.
That is a separate case.
Right. But it was based on the exact same circumstances. Evidence was collected.
Yeah, and there could have been a civil case that went along at the same time as well, potentially, and that wouldn't have any bearing on my case as a criminal case. They're different cases.
Really? So a juvenile case that's based on child abuse has nothing to do with your case on child abuse against those same people and that same child.
Yeah, pretty much.
That just seems ironic. Or that doesn't make any sense at all. A case involving the same people in the same courthouse
Yes.
that would happen in the same courtroom.
Not at the same time, correct?
I didn't say at the same time. I said same courtroom.
Okay.
So none of that would be relevant to you. None of it at all. Not even to see if they maybe say you had nothing, which you didn't. They could have had a key piece of evidence for you in a case, and you would not even look at it because it doesn't involve you. I don't see how that it does, because it's the same people. There's possible evidence there that a prosecutor is choosing not to look at. Anyway, I mean, this basically went how I figured it would go. You trying to not answer questions, because I mean, it'd be hard. Honestly, it'd be hard for me to answer questions in your position. I mean, 3 years, my family went through shit because Phelps County doesn't know how to investigate. Phelps County doesn't know shit about civil rights or parental rights. I mean, my rights were stripped from me from this juvenile. I know that doesn't involve you directly, but I had my rights stripped. They didn't tell me they weren't. But when I have no say, can't see my child, can't do shit, all based on lies that we had evidence to prove against. We went through 3 years of hell. We're still... It's taken me this long to come down to the courthouse because of the anxiety I get. Because we went through what I had to see my wife go through. Our family is tore apart. And I get non-answers. I get excuses. Trying to tell me that evidence that could be key doesn't matter.
It wasn't key.
No, I'm not talking about this, even though you're wrong about that. That's also will be up for a jury in a civil court later down the road.
Okay.
No, I'm talking about stuff from the juvenile case. There was shit in there, like, here's something you apparently had no idea of. Early on, very early on, Judge Calvert, even though he was violating my rights, changed it from a child abuse case to a unruly child.
Okay.
That's because they looked at more evidence than you did, than the sheriff's department did. That's what I'm saying. You're telling me that it wasn't relevant, but yet the juvenile court, when they looked at it, they're like, oh yeah, there really wasn't abuse. This is just a child out of control that's had some issues and needs some help.
I'll have to take your word for it. I am not familiar with the juvenile case.
But you should have been. That's my point. You should have been.
Mr. Brooks, we'll just have to agree to disagree on that. There are things collected in juvenile cases that I can't use.
There are things you can. Or am I wrong on that?
Most of the stuff that I can use out of a juvenile case, I have.
Well, you could have in our case, but you didn't.
I don't know what you're thinking I didn't have. Other than an attachment that wasn't anything. It was a screenshot.
Well, your shitty opinion doesn't matter because you brought charges against 2 innocent people.
Well, we'll just have to disagree about that.
Right, exactly. You can disagree all day long. I strongly disagreed against the charges. And guess what? They finally got dropped. Okay, here's something. How long did it take for you to look at the evidence of the confession that my son had in writing to his mother, the text message, when he said, I never laid my hands on him?
Which one? A text message?
Yes. It was through Facebook Messenger. It was provided in the juvenile trial, and eventually, I guess you looked at it. I don't know at what point you decided to. There was a confession that I never laid my hands on him. if I can remember almost verbatim, he actually never laid his hands on me. Is that also nothing?
If that exists,
If it exists.
Mr. Brooks, it has been months, if not years, since I've thought about that case.
My family went through 3 years of hell and torment because of you and the Phelps County Sheriff's Department and Missouri Children's Division. So I don't want to hear it. I really don't.
Well, I don't care what you want to hear.
Right, and I don't care about your complaints either.
I'm not complaining about anything. Asking me when I remember reviewing something from 3 years ago, I don't remember when I reviewed.
Well, but you remembered this attachment.
No, I didn't.
You said it was nothing. How can you say it's nothing if you don't remember it?
I remember it from like 2 months ago, and since you sent me about 80 emails regarding it.
Well, that's an over-exaggeration. I've sent a lot. 80's an exaggeration.
Okay.
Oh, it's not?
No, I have 92 emails from you between December.
Oh, some, well,
December
you were
21st.
carboned on some of those. A lot of those weren't directly to you.
I fail to recognize the distinction between that. I've
Like
received
2
90
and a CC.
Yeah, we carbon copy people so that way multiple people receive it all the time.
Yeah, but
I've received 92 emails from you.
yeah, okay. Well, okay, that's fine. Say it's 1,000. I don't give a shit. I'll keep sending them.
That is certainly your right.
I know it is. If I would have brought my entire case file if I would have known it was going to be necessary. I didn't know that I was going to have to argue with you over what key pieces of evidence are and how you ignore them.
Well, you're entitled to your opinion if you want it. But
I'm sure the public opinion would most likely agree with me. We'll find out, though.
okay.
So, did you find it?
No, I'm not going to
Okay.
waste my time.
I'll
going
waste
through
your
an
time.
file.
Yeah. But you wasted my family's time. Put
No.
us through hell. Oh, you didn't?
No,
You didn't waste our time.
no.
Hmm.
I still believe that you did really terrible things to Dakota. You treated him poorly.
Oh, wow.
And
Is that what you think, huh?
I do. I met with him several times. I got to know him. He's a good kid. And I saw the effects of this kind of overbearing attitude. That
Being a
comes-
father, protecting his family?
that comes across through emails in person, pretty much in general. I see why he was suffering from many of the things that he was dealing with.
So you're still accusing me of this then?
No, I've dismissed the case against you.
You just said you believe I did it.
I believe Dakota.
That means you believe I did it.
No, I believe Dakota.
Okay, well then do you believe Dakota when he said I actually never laid my hands on him? That's his words. I didn't make up those words.
Says you.
Wait a minute, said no, those are his words.
According to you.
Okay, it's the truth. It should be in your evidence file. If it's not, holy shit.
It probably is somewhere, but I'm not gonna sit
Okay,
here and
but
go through
what?
everything.
So
And I'm not going to sit here and argue with you and nitpick details. At the end of the day, the case against you was dismissed. I still believe Dakota.
wow, you have a terrible judge of character. Terrible.
You're entitled to your opinion, Mr. Brooks.
Yeah, well, I also have evidence.
Mr. Brooks, we are done.
Yeah.
Thank you.
Yeah. No, thank you. This isn't the last you'll see me. Likely, since the Supreme Court changed 42 U.S.C. 1983, you can now be sued for malicious prosecution. So if you think that I actually did it, oh, believe me, there'll be a civil case coming. So you will have your chance to argue that. Because our family, after what we went through, we will have our day in court.
Okay.
So if you believe I did it, by all means, you feel free to argue that in front of a jury.
I appreciate you coming in and seeing me.
Yeah, no, you don't. That just shows how much of a liar. You don't appreciate this.
Sure I do.
You do.
Yeah, why wouldn't I?
Because you're being held accountable for what you did. Oh wait, you don't see anything wrong with what you did. That's right. Right? You don't see anything wrong with what you did. So, my wife, you also believe she did those things, those awful, awful things, huh?
I believe
You believe Dakota.
I believe Dakota.
So you believe my wife did those things too.
No, I believe Dakota.
Well, Dakota said my wife abused him. So if you believe Dakota,
Those are
in
your words,
relation,
not mine. Have a nice day.
Oh, I can't wait to see you on a stand.
All right.
Get you in deposition.
Have a nice day.
Yep. Oh, asshole. Yep. He believes that shit happened. We'll find out. If he thinks so, then why'd he drop the case? That doesn't make a whole lot of sense. So he believes Dakota, but yet, so if he believes Dakota, he should believe him when he said, I never laid my hands on him, but yet he doesn't want to believe that. Then even if you want to believe all the shit about me, you want to say my wife, oh, wait till I get outside and finish. Now that I'm getting outside, even if that asshole wants to try to say that he believes I did that shit, or he wouldn't actually say that, but he believes Dakota. Well, Dakota accused me of shit. You believe him? That's saying that you believe I did it. There's no other way to look at that. But even if that's the case, you want to say my wife, who's never even had a fucking speeding ticket in her life, that she did that shit because you believe Dakota? That just proves how easily he is manipulated. All right, Brendan Fox. You'll have the chance when the lawsuits come to argue your case. Well, that'd be in a federal court, not this piece of shit. So, I knew how it was gonna go, but I still needed to see his face. And I'm glad that I got him to admit that he still believes that shit. So, all right, well, I'm gonna sign off for now. So, I don't even know how hardly ever do this. Here we go. All right, I'm gonna sign off, and it's been a while. I know this shit's it's ridiculous what they do, what they put the citizens through. So, more videos will be coming, lawsuits will be coming. We'll give Fox his chance. He wants to say that shit. Okay, he dropped the case. If he believes it, why would he drop the case? If he believes it, he's going to get his chance in civil court. So, I will see everybody later.